Okay, take your time, but whenever you're ready, you can start.
May it please the Court, my name is Bill McCabe. I represent the claimant, Ronald Jackson. In this case, I'll reserve 2 minutes for rebuttal. Thank you. In this case, the judge of compensation claims denied claimant's request for authorization of treatment for claimant's low back, even though the judge found the low back condition was compensable. And we submit that this is error. The claimant's original injury, the accident occurred in 1984. His original injury was to his left knee. But then starting in 2003, started having low back problems. And he actually started receiving unauthorized treatment from a Dr. Chandler. He filed a petition for benefits in 2007 to determine the compensability of the low back condition. On February 29, 2008, the parties entered into a stipulation where the parties stated the employer carrier has agreed to accept compensability of the back and to provide treatment for the back with David R. Chandler. Claimant goes to Dr. Chandler. For some reason, his report, it's May 12, 2008, it says...
Would they be responsible based on that stipulation for every back injury that existed at the time that the stipulation was entered into?
Yes, absolutely. Because the stipulation says they are accepting as compensable the low back condition.
In Farnham, there was evidence that the original condition, which was compensable, had resolved itself.
Right.
That's how I read Farnham. Can you read Dr. Chandler's testimony in this case to indicate that the condition had resolved itself?
No, not at all. Not at all. In fact, Dr.
Is there any evidence of any change in condition after the date of the stipulation?
No, none. And Dr. Chandler stated his opinion was the same in 2004 as it is in 2008. He was of the opinion all along that the low back was not related to the knee, but that was an issue that could have been decided based on the prior petition for benefits, and that was eliminated when the parties entered into their February 2008 stipulation. And the thing is the judge in this particular case found the low back condition compensable and that they couldn't relitigate it based on res judicata. So really the only issue that should have been here was whether whatever treatment is recommended was medically necessary. I mean, that's because causation has been resolved. But the bottom line is that the judge, I mean, the doctor said, I don't think it's related.
But for the stipulation, there's plenty of testimony the JCC might have relied on to say we don't have the requisite causal connection.
Correct. There could be. But they entered into the stipulation, and so that eliminated that issue.
And then did not adduce any evidence of anything or opinion that came down after the date of the stipulation.
Correct. The only thing different that happened is the claimant, based on the stipulation, went to Dr. Chandler. And Dr. Chandler says, of course, he'd been treating him unauthorized for 4 years, but Dr. Chandler's, his report, like I say, when the claimant went there, he says, or claimant presents to evaluate whether his back condition was related to the 1984 motor vehicle accident. Well, that's not why the patient went there. The patient went there to get treatment per the stipulation. But the doctor states, I don't think his low back condition is related to his knee. So, of course, he doesn't think there's any treatment that he can render for the compensable injury. However, the doctor's opinion is contrary to the stipulation the parties entered into in February 29, 2008. And as the judge found, the issue of compensability of the low back is res judicata. So there's no grounds whatever to deny treatment for this condition that the employer carrier has accepted as compensable.
Let me phrase your argument, put it to the other side. But they could have argued there was a new injury. They could have argued that the injury, if there had been two injuries, one had resolved itself. And if they wanted to argue that the injury which they had already stipulated to, that the treatment really was not needed for that, those arguments would have all been open to them.
I think so.
But none of those arguments are raised here.
No, and there's no evidence to support anything like that. There's no, as Judge Benton indicated, or asked me, there's no evidence that the condition that they accepted as compensable on February 29, 2008 is any different than the condition that existed when the claimant went to see Dr. Chandler, or for now, for that matter. So that's our position in a nutshell, and I guess I'll reserve the rest of my time for rebuttal.
Thank you.
May it please the Court, Mark Massey on behalf of the employer carrier appellees. What the JCC did in this case is correctly distinguish between the concept of compensability on the one hand and the concept of medically necessary and causally related treatment on the other hand.
Or did the JCC really do that? Or did the JCC buy off on the testimony from Dr. Carpenter that there was no compensable injury here at all? Because it seemed to me that's what Dr. Carpenter said.
Well, that's what Dr. Chandler said all along. That's true. When this case was originally scheduled to go to trial back in February 2008 on the issue of compensability of the low back, there was conflicting medical testimony. Dr. Chandler and Dr. Goldsmith both said at that time they do not believe it.
So the EC could have elected to litigate at that point.
They could have elected to try the compensability issue.
But decided not to.
But elected in lieu of trial to accept a compensable low back condition, which is no different than had they gone to trial and the JCC ruling that there's a compensable low back condition. But the fact that there is now an established compensable...
What is different about the condition, the compensability of which they stipulated to at that time, and the condition as it existed at the time of the hearing in this case, as far as the record evidence shows?
The condition of the low back itself, which has had varying diagnoses, is essentially the same. But that's not determinative.
Why not?
Because even though the parties have stipulated that a compensable condition in low back exists, that's no different than had they accepted it as compensable to begin with or had the judge ruled it compensable. But just because a compensable condition exists...
If you had presented evidence and the judge found that there was a compensable injury and made that finding, would you have been able to go back to the next hearing and say there was no compensable injury?
No. In fact, the trial lawyer below...
Okay, so it's exactly the same. So why should you be able to do it here?
Well, in the second trial in this case, or the later trial, the JCC correctly ruled that we do not get another shot at compensability. We cannot challenge that compensability finding.
And you also don't get a shot at whether there was an injury.
No. I beg to differ.
Well, no. Let's go on this. I was on Farnham and Englander, so we got an interesting perspective here.
Okay.
We said in those two cases, number one, if the injury had resolved itself, that was Farnham, that you are no longer bound by the stipulation because there was specifically testimony that the injury resolved itself. You don't have that here, do you?
No, we do not.
Okay. In Englander, we basically said you can't challenge compensability, but what you can challenge is whether the compensable injury caused the need for that particular treatment. You had to assume there was, in fact, a compensable injury, though.
Which there is in this case.
But isn't Dr. Carpenter's testimony in this case, which the JCC seemed to rely on, that there was no compensable injury? And isn't that a relitigation of the issue that you stipulated to?
At the second trial, there was once again conflicting evidence, both on the issue of compensability and on the issue of treatment. Yes, Dr. Chandler, I assume you mean Chandler, still feels, as he did before, that no compensable condition exists. But that issue is done. It's over with. It's been established. A compensable condition in the low back exists. But what Chandler said in his deposition before the second hearing was, I want to do this treatment to the low back, but my opinion is this treatment is not related to a compensable condition. And again, there was conflicting.
That testimony as a whole, isn't he saying that because I don't think there is any compensable condition? And shouldn't we send it back to the JCC to say, look, this is the law. You need to say the question to the doctor has to be assuming that the back condition is compensable. Is this related to that compensable injury? And isn't that the whole issue that needs to be resolved in front of the JCC?
That was the issue that was resolved in front of the JCC.
Well, was it? Point to me where either the JCC or the testimony of Dr. Chandler said, I'm assuming there was a compensable injury here.
I don't know that Dr. Chandler was questioned or said that he assumes there's a compensable injury, but the JCC found that there was a compensable injury. The JCC found that the parties were bound by the prior stipulation that there was a compensable injury. But again, the existence...
And did the JCC make a finding that the compensable injury was somehow different at the time of the hearing than at the time the stipulation was entered into?
No, but she did make a finding based on Dr. Chandler's testimony that the treatment he currently needs and is being recommended is not causally related to whatever compensable condition it is that exists.
Okay,
on the basis of what evidence?
Dr. Chandler's testimony.
Okay, so you admit it was based on Dr. Chandler's testimony. And if you read Dr. Chandler's testimony, isn't his testimony, I don't find a compensable injury here?
Yes, and the inference is, but
okay,
even assuming
well,
a compensable injury exists...
But legally, he's stopped from giving that opinion, right?
I don't believe so. Well, I mean, the employer carrier are stopped from denying the existence of a compensable injury.
Okay, so that's a legal fact.
Yes.
It's required by law. There is a finding that there's a compensable injury. So doesn't the question to the doctor have to be, assuming that this injury, the back as it existed on such and such a day, had a compensable injury, is this treatment related to that compensable injury?
Given that the fact of compensability has already been established and stipulated to, I don't believe so. Once compensability is, just because compensability is established, the employer carrier does not have to, from that point forward, provide any and all treatment to that particular body part.
No, but for that particular injury, they do.
And Dr. Chandler's testimony is that the injury or condition he's treating is not whatever it is that's compensable.
And you know what? The way the stipulation is worded, I'm not so sure they wouldn't be responsible for anything related to the back. If you wanted to stipulate to something, don't you have some responsibility to make sure you're stipulating to a very limited thing? And once you say we stipulate the back injury is compensable, aren't you stipulating that everything related to the back, injuries that they occur on that day, that exist on that day, are in fact compensable?
Well, the stipulation probably could have been drafted a little more artfully. I believe the answer to your question is no. If a carrier says, this claimant injured his low back in this accident and we accept the low back as compensable, and a year later, and this goes back to Checkers and Trimble, a year later, the doctor says, I want to do surgery on the back, but the surgery is due to some personal condition, not to this.
That's not what happened here, is it?
It's very similar. It's not exactly.
There was no other injury or distinct condition identified as an alternative cause.
Well, actually, Dr. Chandler and Dr. Goldsmith all along had diagnosed the claimant with degenerative disc disease, non-industrial strain, scoliosis, aging of the spine. whereas Dr. Dukes and Dr. Sellers, who provided the conflicting testimony, gave sort of a vague
And when you
diagnosis.
say all along, you mean that this conflict existed at the time the EC elected to stipulate the compensability issue away?
Yes, you had two doctors saying they don't believe a compensable condition exists, and you had two doctors saying they do believe a compensable condition exists.
Okay, so what compensable condition did you stipulate then?
Well, that's one of the problems in the case. It says low back. The diagnosis at the time from Dr. Dukes and
Well, if
Dr.
you say that
Sellers.
stipulation is the problem in the case, shouldn't you be able to have to prove your way around it?
We did. Through the medical testimony of Dr. Chandler.
Did you show there are two distinct injuries?
There have been varying diagnoses. There were several diagnoses.
Okay, was there a finding that there were two distinct injuries? Was there any finding that the condition that you found compensable was resolved?
No, nor does there have to be. Because.
Well, isn't that what Farnham said? I mean, it's one of the ways to get around the stipulation. But isn't that what Farnham said? That the issue had been resolved?
No, that's what happened in Farnham, and I don't think Farnham said it. That's
I'm not saying that's the
required.
only way you get around it, but that's one of the ways to get around it.
That's one of the ways, yes. But no, that's not the case in this case. There's no change in condition. There's no new accident or injury. But nor does there have to be, because the principle behind this case is that just because an employer carrier accepts compensability, just because compensability is adjudicated or stipulated to, does not mean that the carrier cannot then contest ongoing medical treatment on the basis that that treatment is not causally related to that compensable condition. I
And
think
if you
Farnham.
can tell me, if it was distinctly determined what that compensable condition was, I think you'd have a better argument. But I'm having a tough time trying to limit it to any particular condition that was being suffered.
It was
or
not.
Any evidence of any change?
It was not described very well below. No, there's no evidence that any change. But again, keep in mind that even at the trial in this case that this order is based on, there was conflicting evidence. Two doctors saying yay and two doctors saying nay. Had the judge accepted the doctors saying yay instead of the ones saying nay, that order just would have been supported by substantial evidence, that it would have been proper, just like this order is. This basically comes down to a case of competent substantial evidence. And the issue is the treatment he needs now medically causally related to this compensable condition? There was some medical testimony that said yes. There was some medical testimony that said no. The judge was free to choose one over the other, and that's what she did.
All right, but the medical testimony that said no proceeded from the premise that there was no compensable injury, the very fact to which, for whatever reason, you had already stipulated.
That's true, but I don't think it changes the analysis or the outcome.
Any further argument?
No, Your Honor. I'll conclude at this time unless there's further questions.
Well, just briefly, I mean, the judge's order and basically their argument is it was nothing more than a relitigation of the compensability of the low back condition. They accepted.
Let me just take the other side of that for a second. Is the stipulation and the accepted fact of compensability, was that sort of a free ticket to get any kind of back treatment the guy needed? Or?
Well, I would argue that they could challenge it on medical necessity. You know, the doctor says he needs a hot tub for his low back. Well, they might think it's not medically necessary.
Suppose he has something that is medically necessary, but truly not caused by the accident, which they have stipulated as compensable injury to the low back.
If it's medically necessary for the low back, they got to pay for it because they have accepted the entire low back. That's what the stipulation says. I don't know if it says low back. I think it says back. Look at it real quick.
So it is kind of a free pass to fix anything wrong with his low back.
If it's medically.
Assuming it's necessary.
Pardon me?
Assuming it's necessary.
Yes. Yes. So they can.
I mean, in other words, if you had a situation where, let's say you have a situation where the claimant really needs to get some kind of disc surgery or something. But the doctors all agree that this has nothing to do with the accident. It really just has to do with the fact that he's gotten old or too heavy or whatever, stenosis. We all seem to get that. And it really has nothing to do with it. But they're still hung, in your view, because they stipulated to the compensability of anything to do with the low back.
Yes, particularly for the 1984 accident, which major contributing cause, I mean, arguably if it was a 1194 or after accident and the degenerative, so they accepted the degenerative condition as compensable. So even under then, yes, they're stuck.
Okay, well, this goes to what, if we buy your position, what we need to send it back for. Wouldn't a better answer be that they have the burden of proof to demonstrate that the new treatment is not necessitated by the injury that they stipulated to?
Yes.
So you don't have a total freebie from the end. So shouldn't what we'd be doing here, rather than dictating that the employer carrier pay for this treatment, shouldn't we send it back for the JCC to readdress this issue under the appropriate standard? You understand my question?
Yes, but to me, it seems as a matter of law at this point that they're required to authorize treatment for the low back.
Well, let me play this out with you.
Okay.
If the doctor said, look, there may have been an injury there that was a result of this accident, and it was probably in existence at the time of the stipulation. I'm not saying this would be the testimony, but that has resolved itself, and this condition in the lower back now is no longer related to that injury.
Well,
they could get around the lower back problem at that point, can't they?
let's suppose somebody had, like one of the cases, there was some unusual disease that the lady had. And the doctor said that unusual disease, that was the, I think, Boston, they cited it, the Boston case. But anyway, that unusual disease was the need for the treatment. But I think that they would have to establish that the low back condition is something different or caused by something different, maybe a subsequent intervening accident, than that which existed on February 29th, 2008. And they've got no evidence of that at all right now.
Well, I'm sorry, but I wanted to ask you, what do you think the remedy is? Because it seems to me you're conceding, or you at least are embracing the possibility of the point I made earlier. But the bigger question is, what is the remedy? It seems to me now, based on what you're saying, that if this is a failure of proof on their part, that is to say, a failure of proof that this really was caused by something else, other than what they agreed to before, that they don't get a do-over. It's just you just win, isn't that right? I mean, what is your take on that?
My take is that they don't have an opportunity to go back, and in fact the judge made that finding, to relitigate the compensability of the low back condition as it existed on February 29, 2008. So if they want to get away from treating of the low back, they either have to show that whatever treatment is recommended is not medically necessary for that low back condition, or that maybe there was a subsequent intervening accident that maybe caused a herniated disc or something like that, that is now the cause of the treatment.
But now, as for the treatment that was sought in this case, they have had their opportunity, have they not?
Yes, they have.
To demonstrate an absence of medical necessity or some other basis for denial of the treatment.
Yes, they have had the opportunity, and they didn't even raise that as a defense. Their defense was that the doctor says the back's not related to the knee. That was the defense that they raised.
So excuse me, go ahead.
Because this is not like an error in admitting or excluding evidence or something where the result would be a retrial or sending back for further findings. Your view, if I understand you, is that this is a failure of proof on their part.
Yes.
Which is essentially then going to be decided in the appellate court one way or the other.
Yes, because the only reason the doctor said that the treatment wasn't related to the accident is because the doctor opined that the low back condition was not related to the accident, which is contrary to the party's February 29, 2008 stipulation, and contrary to the judge's finding in this case that the employer carrier is precluded, based on res judicata, from relitigating I use major contributing cause, that wasn't the standard in 84, but the cause of the low back condition.
But here you are talking about they failed to meet their burden of proof, and of course, the burden is on the claimant.
Burden is always on the claimant, yes, I shouldn't say that, I take that back, but yes, the burden, except for that burden of establishing causation, was met by the February 29, 2008 stipulation.
Because the stipulation not only established the compensability of the injury, but authorized treatment.
Exactly.
By the doctor.
Exactly.
And that was enough, absent contrary evidence. And the only contrary evidence came in the form of Chandler's view that there was a compensable injury.
Which is the same view he had way back in 2004, the same information they had when they entered into the stipulation in 2008, acknowledging or accepting the compensability of the condition.
So again, following up on Judge Padovano's question, as you see it, appropriate relief in this case is what?
Is reverse the judge, find that the claimant is authorized to receive treatment for his low back with Dr. Chandler, and so be it. Then if Dr. Chandler, like I said before, if he recommends a hot tub or something else, they can litigate whether it's medically necessary.
In a separate case.
In a separate case. Okay.
Thank you.
Thank you.